Members, good afternoon. It's the appointed time and we have a quorum. I call the meeting of the Panel on Administration of Justice and Legal Services to order. Item 1 on the agenda, information paper issued since the last meeting. The Secretariat has not issued any information paper since the last meeting. Item 2, items for discussion at the next meeting. That's CB bracket 3671/26 bracket 01. It's a list of outstanding items for discussion. I believe that you've all received it. If I may remind all of you, the next meeting will be held on the 17th of July, Friday, 10:45 a.m. In the next regular meeting, we are going to discuss the proposal to amend the Mediation Ordinance Chapter 620. We only have one item proposed for the next meeting, that is the amendment of the Mediation Ordinance. As a legislative proposal is involved, we are going to invite non-panel members to attend it. Any views on the proposed items? Agreed. Next item, item 3 on the agenda, latest developments of the judiciary's use of technology in court operations. Would the Secretariat please invite the relevant representatives here? We have Ms. Esther Leung, Judiciary Administrator, and her team here to report to us on the item. We also have from the Hong Kong Bar Association and the Law Society of Hong Kong, the representatives. The first set of paper is LC paper number CB bracket 3671/2026 bracket 02. That's a set of paper provided by the Judiciary Administration, JA. The second paper is CB bracket 3671/2026 bracket 01. That's the background brief prepared by the Legislative Secretariat. Members who would like to put questions, please press the request to speak button so I know how many members would like to speak on this item. Ms. Leung, Judiciary Administrator, when you're ready, please walk us through the paper. This paper updates members on the latest development of the judiciary's major initiatives on the use of technology in court operations. We discussed this last June, and this month we visited the Wan Chai Law Court building. We visited the mega courtrooms and the use of technology in court. We also watched some demonstration of the use of technology, including ICMS and the use of artificial intelligence, the remote hearings, so on and so forth. The Judiciary Administrator, whenever you're ready. Thank you. Thank you, Madam Chair. We are here to brief members on the paper that we submitted to the LegCo that's about the latest development of our major initiatives on the use of technology. The judiciary has been committed in making use of technology to enhance the efficiency of court operations while safeguarding access to justice as well as fairness and impartiality in the administration of justice. We have been proceeding at full steam with the implementation of a series of major technology initiatives. Let me brief members of the major initiatives. First, let me talk about the ICMS, Integrated Court Case Management System. In 2022, the judiciary have implemented the system in phases so that users can make payments and handle court-related documents on the system. It can be implemented in personal injuries actions, tax claim proceedings, employees' compensation cases, civil action proceedings in the DC, as well as summons cases in the MCs. Bulk claim cases of the Small Claims Tribunal, selected case types of civil proceedings of the High Court. We're going to extend it to the CFA and other case types of civil proceedings of the HC, criminal proceedings of the HC and DCs, non-summons courts of the MC, as well as non-bulk claims cases of the SCT. As at May this year, approximately 85% of law firms registered with the Law Society have registered for accounts under the ICMS. Around Well, in January, about 13% of new cases were initiated under ICMS. Now, as at May 2026, there are about 73% of them. Starting from the fourth quarter this year, we're going to mandate the use of ICMS for all legally represented litigants in respects of case types where the electronic model's been made available by phases. To boost the utilization rate and enhance training of ICMS among legal representatives during the last transitional period, the Judiciary issued a practice note on the 18th of May 2026, introducing a new requirement. Starting from the 1st of June 2026, unless prior permission has been granted by the court, a law firm that has not previously commenced a case using the ICMS will be required to do so when it next commences a new case in any ICMS-enabled case type in the High Court. We have been liaising closely with key stakeholders in drawing up the implementation arrangements. In April this year, we met with the Law Society of Hong Kong to update them on the latest progress, the proposed timetable, and the new requirement on the use of ICMS for case commencement in the High Court with effect from the 1st of June 2026. To dovetail with the new arrangement, on the 28th of May, we have organized a CPD briefing session for the Law Society, and we have organized a separate session for members of the Small and Medium Law Firms Association in June. We have a help center hotline for the trade. We also have demonstration sessions along with training for the sector. We have reached out to law firms to provide on-site support. Recently, we have streamlined and reviewed the registration process, allowing staff of law firms to complete the registration and activate the accounts for law firms on site, and we provided technical support for the commencement of new case via the ICMS. We'll continue to promote these facilitation and promotion measures so that the trade can adapt to the system. Now let me talk about remote hearing. Since 2020, the Judiciary has been promoting the wider use of remote hearings for civil proceedings. As said, 30th of April 2026, around 2,710 remote hearings have been concluded, and the experience has been positive. On the 28th of March 2025, the court's remote hearing ordinance came into operation. Apart from continuing to conduct remote hearings in civil proceedings, we have extended the use of it to non-trial criminal proceedings, starting with bail applications. This arrangement allows the persons in custody to attend from penal institutions instead of traveling to the court, saving time and resources while avoiding transport-related risks. The experience has been smooth and the feedback is positive. Now let me talk about the use of voice-to-text technology. Since December 2023, the Judiciary has been using the VTT system for JJO's real-time note-taking during court hearings. We are now progressively allowing the use of VTT to produce transcript. In November 2025, we launched a pilot arrangement of producing transcript using text generated by the system for court hearings, and we include the requirements in the new contracts for digital audio recording and transcription services. In the CFA buildings and HC buildings, we now allow for the text generated to be used for transcripts. We are going to explore new modes of operation with a view to enhancing the overall efficiency of transcription work. Lastly, I'd like to talk about the use of artificial intelligence. After making reference to similar guidelines on artificial intelligence issued by courts in other jurisdictions, in July 2024, we promulgated our first set of guidelines on the use of generative AI for JJOs and support staff. According to these guidelines, judges and judicial officers as well as support staff may use artificial intelligence for administrative work such as speech and presentation writing, legal translation, summarizing information, and handling general correspondences, on the condition that they are held responsible for the outcome of such work, and they should check and verify any information obtained to ensure its accuracy and reliability before using. To avoid the compromising on the fair administration of justice, we have not yet recommended the use of using AI for core judicial functions such as legal analysis and judgment writing. At the same time, we are looking into and testing out AI tools for other administrative work. We need to ensure the accuracy and reliability of these systems. We may allow for the use of AI for specific work procedures to enhance our efficiency. Separately, we are now drawing up guidelines on the use of generative AI for legal practitioners and other court users. In the second half of this year, we will consult the legal profession on that. We will make particular reference to specific conditions and restrictions imposed by other jurisdictions on the use of generative AI in their guidelines for legal practitioners. Lastly, for the latest progress on the use of other ICT, they are set out in the paper. I will not repeat them. We'll continue to make good use of technology to enhance the efficiency of court. At the same time, we will keep abreast of the latest development of technology so that while we use IT, we can safeguard against any risk. Thank you. Now, I'd like to ask Mr. Martin Hui, Vice Chairman of the Hong Kong Bar Association, to speak on this item. Please limit yourself to 5 minutes. Thank you. Thank you, Madam Chair. The Hong Kong Bar Association welcome and support the judiciary in the modernization of court operations on the condition of safeguarding administration of fair justice. I believe that the whole legal sector will benefit from it. Technology will enhance judiciary efficiency, and this will make our law more inclusive. Over the long run, this will consolidate our status as an international financial center and a legal and dispute resolution center. As for the various measures, including the ICMS, the use of e-bundle for court hearings, and the adoption of remote hearings for certain proceedings, and the use of BTT, I believe that all these measures will streamline our administrative work. And this will also save us time on documentation and make our court operation more efficient. At the long run, this may lower the cost of litigation and benefit the entire society. We're going from a paper-based operation to digitalization. For specific cases, they can be heard remotely. This will make our legal proceedings more transparent, and this will enhance people's confidence in our rule of law. The Bar Association supports the administration and judiciary consulting the legal sector, and we support the formulation of guidelines on the use of generative artificial intelligence. The Bar Association note that our members are using technology in their daily work, as well as artificial intelligence, along with other tools. Especially for our young members, they are more open to new technology. The Bar Association is also concerned about the risks that relates to confidentiality of clients and the algorithm and the inaccuracy of outcome. In light of this, the Bar Association have established a steering committee and a working group. We're going to look into matters relating to artificial intelligence. The Bar Association is considering whether we should formulate a guidelines for our members to remind them on the points to note when they use AI. We're willing to keep in touch with the judiciary on these matters. We believe that if our members reach a consensus on the principles on the use of AI, and if we can come up with a best practice, then our trade will be able to follow it. The Bar Association supports the judiciary in keeping up with the latest development of artificial intelligence. We welcome them learning from other jurisdictions and update the guidelines regularly. Overall speaking, the Bar Association support all the measures of judiciary on the use of technology. We will keep in close communication with them, especially on the guidelines on the use of generative AI. We're going to provide them with our suggestions.
Thank you. Next, I would invite Mr. Roden Tong, President of the Law Society of Hong Kong, to speak on this issue. And next, I would invite Mr. P.S. Hao, Council Member of the Law Society, to speak on this item. I can give you 7 to 8 minutes each. Madam Chair, Judiciary Administrator, ladies and gentlemen, we understand that technology is developing rapidly, and so we believe that the use of technologies in court operations is essential. Before speaking on this item, I'd like to briefly talk about the use of technology in the Law Society of Hong Kong and our latest development in making use of generative AI and other tools. We have promulgated position paper on the use of AI in the legal proceedings, and we also analyze the challenges that we will face. We emphasize that we have to make sure that the use of these tools would not compromise impartiality, fairness, and integrity. We also suggest that information, participation, and implication are necessary. We also emphasize that we should have a platform to train and provide promotion and education sessions to our practitioners. We then promulgated the second phase of our paper. And recently, the Law Society has organized different activities such as Enterprise Lawyers Youth Summit and also similar summit held in Hong Kong and Macau to address this issue. And on the 17th of June this year, the Bar Association of Hong Kong and Law Society of Hong Kong jointly organized a roundtable discussion. And we have organized this activity very smoothly. We have gathered over 200 practitioners and foster our collaboration. We covered different discussion areas, including protection of privacy, cost effectiveness, challenges, and so forth. We also focused on how to foster collaboration among the different parties and stakeholders. Through the demonstration session, suppliers have shown us the latest development of legal technologies, so that participants could firsthand see how these latest technology could help in our court operations. We also learn how these latest technology can help our daily work. Regarding the ICMS and the use of other technologies in court operations, including the e-bundles and remote hearings and so forth, and also the voice-on-text technology, I would like to defer these issues to my colleague, Mr. Hao. Thank you. Up to 31st of May this year, we have over 900 law firms, and among them, over 700 of them, that is about 85% of them, have adopted the ICMS or have registered under the ICMS account. In order to assist law firms to smoothly transit into this new system, we, starting from 2022, have actively promoted the use of ICMS and also informed them of the latest development of the use of the system. And on the 1st of June, with the practice, we have organized briefing sessions and also demonstration meetings so as to encourage our members to adopt the ICMS. We also encourage them to call the hotlines or go to the center if they have any questions about the adoption of ICMS. The Law Society have also organized different forums and sessions, and we have invited experts from the field to assist our members to know how to implement the ICMS in their daily works. We have worked closely with the government in order to know the timeline for making use of the system. And in April this year, we met the members of the Judiciary so as to further understand the mandatory implementation of the use of ICMS. That is, for those who have registered under ICMS account, these law firms must make use of the ICMS to carry out their work. We support the judiciary in promoting the use of technologies in court operations. We believe that e-bundles and also electronic payment would enhance our efficiency. But in operation, some of our members have voiced some of their concerns. We hope that the system could be continuously enhanced. First of all, they are concerned about the consistency or reliability of the system. Some members reported that during the peak hours, the system would work slower and it becomes not 100% reliable. And since the mandatory date is implementation of the system date is coming close, they believe that the judiciary has to make sure that the system is reliable. And also there is a requirement of changing a passcode every 90 days. Our members believe that this would perhaps cause hassles to the administrators of the relevant law firms. If they have to manage different accounts, that means they have to update the password of these accounts regularly. There might be multiple accounts, so there will be multiple passcodes to update. Sometimes because the password has been expired, they will not be able to enter the system. So they would like to ask the judiciary to review on this requirement to see if it is necessary to really update the passcode every 90 days. Number 3, the Law Society also believes that to mandate the law firms to use the system within this year, in Q4 of this year, might cause great challenges to smaller size law firms. While some of the law firms may not have too many cases involving the High Court. So they hope that the judiciary could make sure that the transitional period is long enough for them to adapt to the new system. Number 4, some law firms believe that the use of the system might cause complexity for firms handling cases with multiple litigants. In handling multiple cases or handling cases that have loads of documents, it might pose problem to these law firms if they are mandated to use the ICMS. So the email actually has no information about the case numbering. So some members believe that it could be improved upon. At present, they have to go onto the system to check which case this is referring to, and this would be extra steps and would cost them a lot more time. So the Law Society suggests that the judiciary could consider adding the case number in the email and also the internal number within the judiciary regarding those cases. That would enhance our efficiency. The Law Society hope that in promoting the use of technology in court operations, the judiciary would also take heed of the concerns of the practitioners and the frontline workers. Regarding remote hearing, the Law Society has been keeping itself abreast of the latest development. On remote hearings, the ordinance came into operation on the 28th of March 2025, and last year we were invited by the judiciary to attend the hearing or the court operations making use of remote hearings in order to better understand the use of the remote hearings technology. And some members opined that remote hearings as a whole are acceptable, but then there are still room for improvement. Remote hearings would enhance efficiency. However, there are sometimes online problems that would affect the court proceedings. And some members also pointed out that there might be some law firms that have their firewall within the system, so that might cause conflict with the remote hearing systems of the judiciary. They have to resolve this problem before going full steam for remote hearings. Members hope that the judiciary could provide a clearer specification about the use of these technology and also the latest version of the hardware that would be necessary in order to make use of remote hearings operation. We hope that all these points could be taken heed of so that we could collaborate fully with the judiciary to make use of these latest technology in court operations. All right, thank you very much. We have heard the opinions of the Law Society as well as the Bar Association of Hong Kong. We have at present 5 members who have pressed the speak button. We have Mr. Thomas So, Professor Priscilla Leung, Mr. Holden Chow, myself, and Mr. Wu Yingpeng. Mr. Thomas So first, 4 minutes. Please. Thank you, Madam Chair. I'm very glad to see this report. I am in full support of the use of technology in court operations in Hong Kong. I've also heard from the Law Society and the Bar Association about their response to this paper. Well, of course, it is inevitable that we might have some teething problem in the implementation of a new system. I hope that the judicial institution or the judiciary would work more closely with both professional bodies so as to calm through this problem. To turn a conventional mode of work to a latest or electronic mode of work, we have to prove to the users that it would save their time, it would be more efficient, more time efficient and cost efficient. And also we have to go forward through trial and error. There are areas that we should further discuss upon and also reflect upon. So digitalization is the main trend. We have to embrace it. But I hope that the judiciary could, in the meantime, perhaps have some regular report to us, and so that we know what are the latest development. I know that there are reports stating that the response is good and there are room for improvement. For instance, for remote hearing, you mentioned in the paper that the feedback is positive. You said that you have tried on over 2,700 cases, but I don't know whether you have a more concrete policy coming up. How do you want to go ahead doing it? Or you could give it, let it, or be a choice to the law firms. I think this is what we want to know as users. And also the use of generative AI is very important. We have the 15th five-year plan from the country, and under which we know that we have to go in full steam for the use of generative AI and digitalization. I understand that the judiciary wants to be more prudent. However, of course, being prudent is very important. It is also important for us to be timely in our development. Can we perhaps have some regular report to the LegCo so that we know what is your latest progress? For instance, you have tried something and you believe that AI could be used on these areas. Well, in the paper you mentioned that you can use generative AI on some administrative work, but is it good? What about the feedback? Is it positive or negative? And for users, especially for us in the legal profession, would really very much want to know about these. And also under the 15th five-year plan, it states that Hong Kong has to bolstered our position as a dispute resolution center, and court proceedings would be very important in order for us to achieve that. So I'd like to know if we have any specific plan in the litigation process, how we could dovetail with the 15-5-year plan. Thank you.
方面嚇，咁啊，你第一
Mr. So put 4 questions. I'll be more lenient with you because you're the first to ask questions. The Judiciary Administrator, please. Thank you. Regarding ICMS, we've heard the feedback from the Bar Association and the Law Society. All along, we have been providing technical support to members of the Law Society. Some of the comments we heard before, for specific cases with a large number of litigants, some law firms ask for more facilitation measures. We are considering it. For this reason, in June, we put in place a transitional arrangement. That's because we don't want to see problems when the mandatory requirements are implemented. The percentage of new cases initiated in the ICMS is low. We will continue to improve the system. Second, on remote hearing. The relevant ordinance states very clearly that the legal proceedings of criminal cases cannot be done through remote hearings. For non-trial criminal proceedings, such as bail applications of persons in custody, they can use remote hearings. We have to adhere to the provisions in the ordinance. The judge will consider a basket of factors, including the views of both parties. Going forward, of course, we want to have more cases covered by the remote hearing arrangement. This will enhance the efficiency of court hearings and safeguard the administration of justice. As mentioned in the paper, we are already using different generative artificial intelligence for administrative work and tasks. Different AI engines and systems have different functions. Overall speaking, AI is beneficial to our efficiency. As with our guidelines, all users have the responsibility to verify and check information obtained from AI. For core judicial functions, there is no AI tool that is suitable for these yet. Now we're looking into whether there is any large language model available that can help JJO improve their efficiency. We are currently researching into this area, and we're happy to report a progress of our research to the panel regularly. Given our constitutional duties of the judiciary, we are striving to safeguard access to justice and enhance our efficiency. Our efforts have been dovetailing the 15-5-year plan. Next, Professor Priscilla Leung. Thank you, Madam Chair. The judiciary needs to make use of technology in court proceedings. This is a trend. I'd like to ask about the use of AI and remote hearings. I'm concerned about the accuracy, the popularity, the exceptions, and security. I have been a member of the BC to the court remote hearing bill, when witness is giving evidence in remote hearings, do we have enough facilities to make sure that there is no one threatening the witness when they give evidence, in the sense that they are doing it unwillingly? Maybe we can ask the witness to give evidence in some designated government premises or law firms. I know that our resources is limited. We may not be able to send our staff to monitor the process. Second, accuracy. I also visited the law court together with other LegCo members this month. AI makes mistakes, as you also mentioned in your paper. We need to make it clear to the public that AI is just to streamline our administrative tasks. We're not going to rely on the outcome of the AI, because as you demonstrated in our visit, AI sometimes make mistakes. We need to tell the legal sector that they have the responsibility to check and verify the information. They should be held responsible to the outcome of the AI tool. On the popularity of technology, well, many lawyers prefer secretaries that are human. Can we offer exemptions to them? In June, you're going to make the use of ICMS mandatory. There are some legal practitioners that are not well versed in technology. Maybe we should offer them some grace period. Some lawyers are just not good with tech. How are you going to address this issue? Lastly, I know that for some cases, live broadcast is not available for the entire legal proceedings. There are some cases that are not suitable for being live broadcast. I'm glad that you have excluded some of the cases from live broadcasting. Thank you. GA, please. Thank you, Professor Lang, for the questions regarding the use of technology and remote hearings. We don't allow for the remote hearings for all cases. Whether the environment where the witness or the litigants are in is suitable for a remote hearing is a factor of consideration. That's why we only allow persons in custody in the penal institutions to use remote hearings, because penal institutions are guarded by our correctional staff. For other cases, if the witness involved may be subject to control, and if we're not sure whether the witness can attend hearings independently, the judge may choose not to hand down the remote hearing order. We're only going to select suitable cases for remote hearing. Lastly, on the accuracy of artificial intelligence. You've watched the demonstration of VTT technology in the courtroom. In other jurisdictions, we understand that the average accuracy of VTT is about 80%. VTT can only replace note-taking of judges. It cannot replace the entire transcription service. It nevertheless plays a very important role, because having VTT means that we don't have to do everything manually. For transcription service, We can use VTT, but we cannot wholly rely on it. We allow for the use of VTT generated version as a draft for transcripts. However, staff still need to verify the text thereon. As for ICMS, very soon we're going to amendate the use of it in October. In June, we ask all law firms that have not previously commenced a case using ICMS do it in June. And this is very effective. The percentage of new case initiated under the ICMS have been increasing substantially, and we're confident that going forward, law firms will be more used to using the system. We're not going to mandate the use of ICMS across the board in October. We're going to do it in stages. We are only going to cover cases that have already commenced, and when new documents are required, the law firms involved will have to do it via ICMS. The technical issues mentioned by the Law Society, we take note of them. As for live broadcasting, we are only broadcasting cases in the Court of Final Appeal. For highly politically charged cases, national security cases, they are not covered. We have done a dozen of live broadcasting. The feedback has been positive. About 1,000 people watched our live broadcast. After the pilot scheme, we're going to review it to see if there is any improvement that can be made. Please do not repeat questions put by other members. Mr. Holden Chow. Thank you, Madam Chair. I thank the Judiciary for inviting members of the AJLSP to the court building. They've given us a demonstration on the use of technology in court operations. I have a few comments. I have to declare interest. I have my own law firm. I've registered as a user of ICMS. Regarding the requirement to change your password once every 3 months, some law firms may find it annoying. I'm sure that the Judiciary have heard our views and they will make an improvement. I've used ICMS and I think it's easy to use. I think that law firms that have not commenced any case using ICMS, maybe the Judiciary need to send their staff to the law firms to provide support. Second, I said this before during my last visit. As mentioned in the paper, for criminal proceedings, they can only use remote hearings for first hearing only. In some magistrates, many cases are handled in the morning. If you use remote hearings for first hearings, sometimes it takes longer time because of technical issues. I think that in-person hearings can be efficient because in the morning there are many cases that are processed in the morning. I think that we have to strike a balance. Lastly, on artificial intelligence, We need to be mindful of the conduct. In the future, things generated by AI may become evidence. We may need more experts to discern evidence generated by AI. And there's recently been a case on this in the United States, and I see articles on it written by our fellow lawyers. I think that we have to look into it. Thank you. Please.
Thank you, Madam Chair. Thank you, Mr. Chow, for letting us know your views on ICMS and remote hearings. We will continue to handle these issues prudently. Please rest assured that not all cases could be done through remote hearings, and only short cases like mention hearing could use remote hearings. For summon cases, as mentioned by Mr. Chow, it is true. It won't really raise our efficiency by using remote hearings, and we couldn't do any testing beforehand. So basically, we use remote hearings on cases that we believe would help us enhance our efficiency. We have guidelines to the judges and other judicial official and other court users. We will make use of the practice of other judiciaries or other jurisdictions, including implementation of these technologies and also the submission of evidence and so forth. If we make use of AI to generate these documents, what would be the result? We are now looking at the examples of other jurisdictions to see the pros and cons. Next, Mr. Wu Yingpeng. Thank you, Madam Chair. Digitalization in court proceedings is a must. I believe that the use of ICMS could help enhance our efficiency. So I am in support of this system. I'm more concerned about this. If one party is represented by legal persons, what about the other litigants who are litigant in person and are not legally represented? They are basically from the grassroots and class. So how can we make sure that there is fairness and imperative between the two parties? We should avoid victimizing the parties that are not using the ICMS. Or, put it differently, we should avoid giving favor to those who make use of ICMS. And also, if one party is legally represented and the other is not, and if the court prefers to conduct hearings in a conventional way, how could we make sure that both parties could accept this decision? Yes, the ICMS it's actually free for the litigants in person to choose whether to use ICMS or not. In other words, the litigants in person could register under the system so as to become a user of the system. The person could also submit his documents or evidence through ICMS. However, that said, we would not victimize those litigants in person who choose not to use ICMS. So for these group of people, they could still have the freedom to choose whether to use ICMS or not in the court proceedings. Well, if there are cases that would require submission of documents to the court, if it is to be submitted in paper, then we require them to have another copy, electronic copy, so that it could be kept under the ICMS. In that case, we would have a more comprehensive record database for these court papers and court documents. So they could upload their paper document onto the system. We started to have this service from the end of last year, so it would not affect people who are not using ICMS. And it would not victimize people or litigants in person who are not using ICMS. Thank you, Madam Chair. All right, next, Mr. Janice Ho. Madam Chair. Well, in my view, I think ICMS is a good way forward. I'm in full support of it. Well, actually, we are lagging behind the mainland practice. They have started using electronic documents and also remote hearing long ago, especially during the COVID time. They have started to use a remote hearing in court cases. And after the hearing, they have a transcript almost immediately. So people, the different parties could verify the documents on site, actually on the spot. And then people, relevant parties have to sign on the documents in order to rectify the document before they leave the court. So I think they are actually more advanced than us. They are actually 4 or 5 years ahead of us. They are very courageous, very bold, with good vision, that they have started to use this system. Well, for us in Hong Kong, we started to use it recent years, and we try to implement it by phases. It's a good thing, though a bit late. But anyway, my suggestion is that after the hearing, the transcripts are actually lagging behind. They have to take leave, and after that, we have to wait for the translation team or IT team to verify the transcription. They have to make sure that it's 100% accurate. Of course, it is understandable. We want to make it perfect and totally accurate. But then, is it reasonable? I think if the user finds it acceptable, that should be okay. Because if you really want to make it 100% perfect, we would need to spend a lot of time. We do have audio recording, and those transcripts were generated by AIs already. Of course, there might be some inaccuracies. We could actually take the draft first. We don't need to apply to the court. We don't need to have to leave from court. You could just make use of these draft transcript in your trial. It's just for your preparation. It's a kind of a tool. It's not a history or historic document. So you can just make use of this draft generated by AI. If there were discrepancies between the transcript and the audio recording, then you could check from the audio recording, and the recording should prevail. Well, I think we should provide a transcript to the parties right away. It doesn't have to be perfect and 100% accurate. Well, of course, you can check your notes. I believe that we should do that in order to make sure that we're not lagging behind too much. All right? To respond to Mr. Ho's question, for transcript, under the present system, people have to apply for the transcript through the court. If they require speedy production of transcripts, we could do that within, say, 3 working days. We are having a trial from the end of last year to May this year. We have about 10% of the transcripts that were generated through the ATT system or VTT system, and we could see that there's a saving of a lot of time. For the situation pointed out by Mr. Ho, my understanding is not about the final transcript. You're talking about the VTT transcript, right? Of course, it is not 100% accurate. It is acceptable because, technology speaking, on average, the accuracy is about 80% for transcript produced through VTT. For Chinese, the accuracy rate is about 70%. So for these transcripts, it could assist the judge in checking his notes, in writing his notes on the cases, and it could help both parties, the defendants and the litigants, to make use of this transcript to refresh their memory. Well, of course, the transcript has to be very accurate because some parties may apply for appeal, so they would need a very accurate transcript. But if you say you just need a draft, a written draft generated by VTT, that is a different matter. We have to set out how we could produce this VTT drafts to users. Mr. Leung? Dennis Leung. Thank you, Madam Chair. we're talking about digitalization in the government. I believe that different departments should try to make use of technology as much as possible to streamline their work process and enhance their efficiency. In the paper, most of the contents are about the use of AI before or during the litigations. But my concern is about the post-hearing process. Well, I received a case recently. A party got divorced about 10 years ago, but then the party has not received the 7D form. So this person went to Admiralty, and this person had to queue up for about an hour, and then this person was told that he had to pay in order to get the form. So he had to queue up again to pay, and then after that he returned to the original line, and then he spent another hour before he could get that form. A lot of government offices or departments, like the transport department, people have to queue up in different lines in order to get things done. But for the transport department, I think they have improved. They have turned or provide the services in a one-stop way, so the users could only queue up for one time. But then for the judiciary, it seems that we're still not doing that. We have to ask the users to queue up for multiple times in order to get things done. Well, perhaps in the past you had different staff. Some people were responsible for getting payment, the other were for registering or for handing out forms. But then have you ever considered how to streamline the process and concentrate of your resources so as to provide a one-stop service to the users, so that people would have a better experience in visiting these government departments to get things done? And there might be frontline staff who are sitting there only to receive payments. Some are sitting there only to receive forms. So these are repetitive and very simple work process. Can we perhaps integrate these work processes so as to provide a one-stop service to the users? Thank you. Thank you, Madam Chair, and thank you, Mr. Leung, for your suggestion. Well, we are working actively to improve on our work processes with the use of ICMS. For the legal representatives or the judicial JJOs, they have given us very positive feedback. Well, in the past, after court hearings, there might be a paper. You have to wait for the clerk in the court to turn the documents in, or to give the documents back to the registry or to the accounts office, and then they have to get a ticket to queue up to get the documents. But now everything is automatic. After the hearing, they could actually do their payment electronically. So we are still trying to improve on our work processes. We are also looking into how to install automatic machine, like self-help machine, so that the users could submit payment electronically. They do not need to go to the court, do not need to queue up to do so. So all these kind of streamlining are ongoing. We will continuously try to improve ourselves so as to streamline the entire litigation process. It's not just on documentation or submission of evidence. It's all round. It should cover all aspects of the entire proceeding. Thank you. All right. Mr. Leung, you've heard from the judicial administrator. They hope to digitalize their proceedings in the entire court operations. Well, it's my time to put question. I'd like to thank the Law Society and the Bar Association of Hong Kong for giving us their views on the paper. Well, to me, I feel that the paper are basically functional. It's about how the ICMS could be implemented and in what are the different stages that it will have. And also, I heard about adding the case numbering on the court email. So these are very practical. I hope that the judicial administrator could take heed of these views and concerns. Well, If you can give possible feedback right on the spot, of course, we will welcome that. If not, please bring these views back to consider them thoroughly. And also about the guidelines, it is mentioned that in executing core court proceedings, the use of generative AI is not recommended. Well, in our next stage, we would be setting out guidelines for the practitioners. Are you going to adopt the same principle or the same requirements? Or you would make a reference from other judiciaries to see which would be the best way to go? And what sort of jurisdictions you are making reference from? Can you tell us about that? And also, you're telling us that you have made drawn reference from other jurisdictions and trying to see what would be the best way to go.
問題啦，關於 ICMS
Thank you. On the operation of ICMS, we note the trade's views. Regarding the requirement to change password every 90 days, we've made reference to the practice adopted by the government and other NGOs. This is commonplace. We may relax the requirement. We note the trade's comments and we're looking into it. Second, when a large number of litigants are involved, how can we include the serial number in the notification? We will look into the technical aspect of it to see if it's feasible. And if not, how can we make things more convenient for the trade? We'll follow up on them. Second, on the guidelines on use of generative AI for legal practitioners and other court users, we will definitely refer to similar guidelines in other jurisdictions. In Singapore, Australia, they already have similar guidelines. We'll look into them. They, in general, don't ban the use of AI among legal practitioners because that's not practical. All we have to consider is there is other restrictions on the processing of evidence and representations of experts. Do we need to impose additional requirements when they submit these evidence to the court? These are the things that we're looking into. Nevertheless, these guidelines affect legal practitioners in using AI to process legal documents. We're going to consult the legal profession. The judiciary will not just publish the guidelines on their own because it affects the entire profession. We're going to consult the trade. How long will the consultation period be and when are you going to publish the guideline? We don't have a timetable yet. We plan to start the consultation at the second half of this year. We will prepare the consultation document first. Generally speaking, we're going to give the legal profession ample time to give their views. Mr. Thomas O would like to speak for the second round. Dr. Junice Ho also. Can you put all your questions and then I will ask the GU to answer your question. Thank you, Madam Chair. I'd like to follow up on my question of a 15th five-year plan. Apart from using technology to improve the court proceedings, does the judiciary have other plan to promote their work in response to the 15th five-year plan in enhancing the legal and dispute resolution efforts of the judiciary? Dr. Ho, I just want the judiciary to enhance efficiency and effectiveness. They said that just now that there is a distinction between transcription and text. We have a stricter requirement for transcription. You said that you will actively look into it. You don't have to look into it, you just have to do it. Just ask the staff to print the text generated by VTT out. When the person requests for a transcription, you can just print the text out and ask them to verify the text thereon by themselves. I think that we need to go full digital, and we need to make good use of the ICMS. I don't think we need the consultation document. People have views, they will let you know. If you think their views are reasonable, just adopt them. I think that consultation period is redundant. The JA, please. Thank you. I thank Mr. Ho and Dr. Ho for the comments. In the 15th five-year plan, as I understand, the judiciary is tasked to safeguard access to justice fairly and impartially. The judiciary is independent in the basic law, and we are tasked to process all cases efficiently. We act in accordance with the basic law to hire enough JJOs to handle all our cases. We try our best to keep abreast with the time, and using technology, we are trying to streamline our procedures to enhance our efficiency. Recently, we have this new measure. In the coming year, we're going to establish our first commercial court. This is our new plan, and we're going to complete our task in 5 years' time. We'll continue to repair and maintain as well as upgrade our court facilities. In 2027, we're going to have a new district court. We're going to streamline our procedures there. Over the long run, we are going to redevelop the High Court. We believe that all these efforts dovetail with the 15th five-year plan. There is a distinction between note and transcription. We're going to use VTT technology flexibly. In the interest of time, I know that it's difficult for you to answer how Judiciary will dovetail with the 15th five-year plan, what measures and plans they have. If you don't mind, can you write to us about how you safeguard access to justice, how you enhance efficiency and effectiveness, and the commercial court establishments, as well as your plan and how they dovetail with the 15th five-year plan? Please give us a written reply. Thank you. The judiciary is not a government department. We are not tasked to submit a report under the 15th five-year plan. If we think that their plans and directions that dovetail with the five-year plan, we may give the government a report, but that will not form part of the Hong Kong's five-year plan. If the AJLSP wants the judiciary to give them a report on our plan, our way forward, we're going to submit a report to you. Thank you. I think that's it for this item. Now we are going forward and we proceed to item 4. Thank you, JA and your team. The next item is latest progress of hosting international legal and dispute resolution organizations in Hong Kong, including the International Organization for Mediation and the International Institute for the Unification of Private Law. Would the Secretariat please invite the government officials to come in? Please note the following paper, LC paper number CB-3671/2026-4, paper provided by the DOJ 05. That's the background brief prepared by the Legislative Secretariat. With us here today are Mr. Paul Lam, Secretary for Justice, and his team. We also have representatives from the Hong Kong Bar Association, Mr. Adrian Lai, and we also have the president from the Law Society of Hong Kong, Mr. Tong and his team here. Secretary for Justice, when you're ready, please walk us through the paper. I will open the floor for members to press the request to speak button. Secretary, whenever you're ready. Thank you, Madam Chair. I thank the members for attending this meeting. To dovetail with the 15th five-year plan, the Hong Kong SAR is positioned as the three centers and a hub. The DOJ is determined to maintain the established status as an international legal and dispute resolution services center of Hong Kong. We'll continue our work in enhancing collaboration with various international organizations and further contribute to our country's effort in promoting foreign-related rule of law. I'm happy to report to the panel that the DOJ is going to report to members the progress concerning the hosting of headquarters of IOMET and the establishment of the liaison office of UNIDROIT. On the 30th of May 2025, the IOMET headquarters was established in Hong Kong, and it is the first ever intergovernmental international organization that establishes headquarters here. The IOMET have just handled an international dispute recently and reached a consensus. The Governance Council, composed of representatives from contracting states, serving as its decision-making body. The Secretary General is Professor Teresa Cheung. The National 15th Five-Year Plan supports the furtherance of the role of IOMET. Although the government will not directly participate in the operation of it, it will maintain communication and liaison with and fully support the facilitate the development of IOMET, working together to develop Hong Kong's position as a global mediation center. We're going to offer office space to IOMET as well. We will also organize events with IOMET with support from the DOJ. In the 2026 Legal Week, we organized the Global Mediation Summit. The SAR government will strive to provide promotional opportunities for IOMET in international conferences such as the Belt and Road Summit, the APEC Finance Ministers meeting to be held this year. On UNIDRAFT has its headquarters in Rome, Italy. They are going to set up a Asia-Pacific liaison office in the Hong Kong legal hub with a strong support from the central government. In December 2025, the proposal to establish an Asia-Pacific liaison office in Hong Kong has been approved. The liaison office will be the first overseas office of UNIDROIT in its 100 years of history and will be opened in Hong Kong as part of its renowned international organization's centenary celebrations. This shows their confidence in Hong Kong. The SAR government is working on preparing the establishment of the UNIDROIT. We have signed a memorandum of administrative arrangement with the UNIDROIT, which set out the administrative framework regarding the establishment of the liaison office. We are now furnishing the office premises to house the liaison office in the former French mission building. They are starting the recruitment of staff already, and the opening ceremony will be held in early November during the Legal Week. 2026 is targeted that the office will be staffed and ready to commence operation by the end of 2026. The establishment of the liaison office will oppose opportunities for the legal trade, and we can deepen exchanges among the sector. With the presence of the IOMET headquarters and the upcoming establishment of UNIDROIT's liaison office in the Hong Kong SAR, this shows that Hong Kong is competent as a legal and dispute resolution center, and this highlights our advantage as a bridge connecting the East and the West. We will continue to deepen our collaboration with other jurisdictions and pull together talents from other jurisdictions. We will continue to create opportunities for the trade. Thank you. Now I will ask Mr. Roden Tong, President of the Law Society, to speak on this item. Please limit yourselves to 5 minutes.
Madam Chair, Secretary for Justice, members, I would like to speak on behalf of the Law Society of Hong Kong on the establishment of the IOMAT and the Liaison Office of UniDroit. First of all, IOMAT is an international organization. The convention was signed in May 2025 so that Hong Kong would set up the IOMAT in Hong Kong. And it shows that Hong Kong is a shining example of a place where East meet West and also a legal hub in the region. The Law Society is glad to see that the IOMAT has handled the first case regarding maritime disputes. The case is still at an initial stage, but then it shows that the IOMAT is very helpful or can give practical help in resolving these kinds of disputes, and it also shows the strength of Hong Kong in having its the IOMAT here. The organization actually is the first of its kind that was established outside of Rome, its headquarters, and the liaison office will also work with the United Nations relevant office and the Hague courts to collaborate jointly together with them to continue to foster the work in mediation and dispute resolution. It shows that people have confidence in Hong Kong in conducting a dispute resolution. It also would help Hong Kong to participate in the formulation of international order and will further strengthen Hong Kong's position or preeminence as a global legal hub. The Law Society has been working closely with the Judiciary. In January this year, we have gathered legal practitioners from different jurisdictions to the IOMAT and met with Professor Chang to discuss how we could join hands together to foster exchange. Participants include participants from the International Legal Federation, relevant legal parties from Milan and other countries. This event helped different parties to understand the strength of Hong Kong in carrying out dispute resolutions. The Law Society also has worked with different stakeholders to see how we could put forward more professional mediation services under IOMAT. For instance, the mechanism for dispute resolution on kind of medium and large size commodities disputes. The Law Society also welcomed the Asia Pacific Liaison Office to be established in Hong Kong. The Liaison Office could help to promote Hong Kong as a dispute resolution center in the region. It will also provide more opportunities for our legal professionals to participate in this work. Well, this is in line with Hong Kong's strengths in fostering quality legal services and also trying to participate in the formulation of legal mechanisms in the world. I have joined the chief executive in visiting some other countries for instance, in Kazakhstan, and we introduced to these people about the strength in Hong Kong, about our international dispute resolution services. Hong Kong, as the only place of our country which is practicing common law, we have our unique strengths, and we could also provide national disputes. And the Law Society representatives have also conducted discussion with the other participants of this exchange session. We also have fostered the collaboration between Hong Kong and other countries. These collaboration will help the exchange of the legal professionals in our places and also help provide more quality and comprehensive legal services to the community. And from the positive response of the participants of these exchange sessions, we could see that Hong Kong has a unique role to play. We have our unique strength, and we also have a very good development prospect. The IOMAT liaison office establishing in Hong Kong could help us in doing this work. It provides a very important platform for us to carry out this work. We also have organized or participated in different legal exchange forums and conferences. We also introduce our strengths to other participants and also to our counterparts in other countries. With the opening of Unidroid, we believe that Hong Kong can continue to play an important role in on this front. We could assist or provide more important legal services to relevant parties. We also could consider or could establish ourselves as an important global legal hub. We could also carry out more contributions in nurturing professional talents and also in fostering exchange between the legal professions of different countries in the region as well as globally. We can also bring in a new development opportunities of the legal field. With the development of our legal profession, Hong Kong will continue to give our strengths and contribute our efforts in the dispute resolution and establishing Hong Kong as a legal hub in the region. Next, I would like to invite Mr. Adrian Lai from the Hong Kong Bar Association to give your views. Thank you, Madam Chair. We're very glad to see that Hong Kong is continue to put in effort in building Hong Kong as a legal hub. And in May this year, the IOMAT was established in Hong Kong, and this effort is actually in line with the United Nations Convention, and this year we will welcome the establishment of another very important institution, that is Unidroid, the International Institute for the Unification of Private Law. With the establishment of these two very important institutions, it shows the confidence that people have in the legal profession and legal strength of Hong Kong. The IOMAT operation in Hong Kong shows that Hong Kong has its own strength in providing dispute resolution, and it also shows that we could showcase our strength as an international legal hub. We could also build stronger connections and promote international legal talent exchanges and collaboration. Well, we have 24 mediators on the mediation list, and about 17 of them are from Hong Kong. The Bar Association will continue to give full support to the work of the IOMAT, and we will continue to equip our members to provide quality services in order to carry out dispute resolution in the region. And through that, we could bolster Hong Kong's position as a legal hub in the region. As for Unidroid, we are also very glad to see the establishment of Unidroid in Hong Kong. Unidroid is a very important institution, and they decided to establish the Asia Pacific Liaison Office in Hong Kong. And this office will be the first ever overseas office of Unidroid in its 100 years of history. And our members have been keeping close collaboration with Unidroid. In 2023, we invited Unidroid representatives to come to Hong Kong, and in the first half of 2023, our member, Mr. Lau Chuk-kei, through the arrangement of the Judiciary, have been seconded to work for 6 months in Unidroid. And I myself have worked with Professor Tirado to talk about the work of Mr. Lau, and his work was highly commended, and we look forward to continue to have this opportunity to send our young members to work under Unidroid or to work in international institutions such as UNIDROIT. And especially after the establishment of the Asia-Pacific Liaison Office of UNIDROIT in Hong Kong, we believe that our collaboration exchange with UNIDROIT will continue to strengthen. And we are glad to see more exchange opportunities between our members and members of UNIDROIT. And it would facilitate us in capacity building. Thank you very much. Now is the question time. We have Mr. Holden Chow and Priscilla Leung, Professor Priscilla Leung, who have pressed the button. Mr. Chow, please. Thank you, Madam Chair. IOMAT establishing in Hong Kong is really very encouraging and heartening to us. And similarly, the establishment of the liaison office in UNIDROIT in Hong Kong is also very encouraging. This will be the first overseas office of UNIDROIT in its 100 years of history. It's really a good recognition of the strength of Hong Kong, and it's also a good chance for us to promote the importance of Hong Kong and our rule of law. We have heard the views of the Law Society and the Bar Association, and they have actually had a lot of exchange with IOMAT and UNIDROIT. I remember that every year during Hong Kong Legal Week, we very often have guest speakers from UNIDROIT. So my question is, since they will have the liaison office in Hong Kong, will the Secretary for Justice consider how to make use of these opportunity, for instance, to line up with the Hong Kong Bar Association or Law Society to go overseas to the member state of UNIDROIT so as to promote the rule of law of Hong Kong and also the special strength of Hong Kong. We also have a lot of papers or documents that have drawn reference from the member state of UNIDROIT before we drafted our legal documents. So perhaps we could also visit countries in the Asia-Pacific region, and it might be able to help them to draw reference from our legal documents so as to help them set up the template or the kind of format of these kind of documents. Secretary, thank you, Mr. Chow, for your questions. Let me talk about the present situation first. As Holden understands, we have been working closely with UNIDROIT actually for quite a long time. You have cited one example, that is we have some private law summit every year. This year is their 100-year anniversary, so we have special activities arranged. Today is 22nd of June. Actually, in Shanghai today and tomorrow, through UNIDROIT, we actually have new collaboration projects signed up. So every year we would send our members to the mainland to carry out different activities. Last year we went to Wuhan, talking about the importance of international arbitration. And this year in Shanghai, we have similar a summit about international arbitration, and then later on we'll come back to Hong Kong to have similar activity. So these are just examples of what we have been doing together with UNIDROIT. We hope that through this liaison office in Hong Kong, we'll be able to do more work on this front or do more new things. One of the most very important thing is that the liaison office will have a director of liaison office or a liaison officer. They are actually recruiting this person, and the liaison office officer will promote the work of the liaison office of UNIDROIT. And actually, the views or the vision of UNIDROIT and Hong Kong legal profession are actually the same. Looking at our past experience, we know that there are lots of room for further collaboration. So I really look forward to the establishment of the liaison office. They will have a designated person in Hong Kong, so it will be more helpful for us to facilitate closer collaboration with them. And in the past activities, it wasn't just staff of DOJ who work with Unidroit. We also have members of the Bar Association or the Law Society of Hong Kong, and also other law practitioners in Hong Kong to join in these activities, so that together we could work with Unidroit and learn from each other.
Professor Priscilla Lang. Madam Chair, I'd like to congratulate the Secretary for Justice. We now have the liaison office of the Unidroit set up in Hong Kong. This is great news. The 15th five-year plan states that Hong Kong should assist in the construction of the foreign-related rule of law as a dispute resolution center. Last Wednesday, I moved a motion on the two goals for Hong Kong. First, we need to become the most stable and freest investment hub. In order for us to achieve this goal, we need to build a brand for our legal services. I know that the Secretary for Justice is working towards this goal together with the trade. The commercial court is about to be established. Now I have a question. In order for us to realize these goals, we need to pull together talents from all over the world, from not just the mainland, but other countries. If we can achieve this, then we can compare ourselves to the Legal Talent Training Academy of The Hague. We have many legal talents from the mainland coming to Hong Kong. I think that we need to expand further. We can start with the countries along the Belt and Road countries, our initiative. Now on dispute resolution. The commercial court, the Unidroit, and the IOMED, what is the division of duties? We want to formulate international rules on commercial cases. What about arbitration and mediation? For mediation, we focus on outcome. As we promote this among the public and international society, I think that we need to set out clearly the division of duties among the three dispute resolution centers. The Secretary for Justice. Thank you. There are three questions. On talent training, Professor Leung is a member of our expert panel. I'm sure she understands that a target is not just legal talents from the mainland. Our country attaches a lot of importance to promoting foreign-related rule of law. So we need to attract talents from other countries as well. We want to attract talents from not just mainland. We just organized the seminars to facilitate understanding of the laws in the mainland among our legal professions. Now, in terms of our way forward, we will work closely with the mainland to attract more talents from country along the Belt and Road initiative and work on capacity building with international organizations. The Belt and Road countries are interested in our country's system. But they also need to know that there is a place that adopt a common law system, that is Hong Kong. So we do have our own characteristics and features. I think that as our country promote their legal training, they should also include Hong Kong. Hopefully, in the near future, we can have some concrete plan. Now, on dispute resolution, we promote a diversified and comprehensive dispute resolution service. It covers mediation, litigation, and arbitration. Usually, mediation is the first step. If it doesn't work, then we have to go for litigation or arbitration. We're working on all these three fronts. For mediation, we have the IOMED. Last week, the DOJ just reviewed the monetary mechanism on mediation. In order for us to become a capital of mediation, we need to make it popular, we need to make it professional. Now, on arbitration, we're reviewing our legal framework. Hopefully, by the end of this year or early next year, we can formulate a framework after consulting the legal profession. Now, on litigation, that's the work of the judiciary. I think that the question's been put to them in the last session of this meeting. We're about to have a commercial court to process international disputes, and hopefully we can attract leaders in handling commercial disputes, and this will make Hong Kong more attractive. I think that we need to make Hong Kong more diversified so that people can come to Hong Kong for different kinds of service. We note Professor Leung's suggestions. We have 3 different dispute resolution mechanisms. Regardless of what kind of service people need, they can come to Hong Kong. Next, Mr. Alex Fan. Thank you. I have 2 questions. They're about the IOMED. According to paragraph 6 of the paper, as at the 2nd of June 2026, the number of signatory states to the convention has increased to 43. But the number of contracting states that have completed the ratification process has increased to 14. So there's a discrepancy of some 29. So the ratification process has not been completed for some of the signatory states. I know that the IOMED is an independent organization that is located within the Hong Kong SAR. As we are housing the headquarters of this important intergovernmental international organization, does the SDR government have any ways to play a role in helping signatory states completing their ratification process? How can we encourage more countries to join IOMED? Second, now looking forward, I'm glad to hear that the establishment of the liaison office of UNIDRA is smooth. Apart from that, what plan do we have in attracting internationally renowned legal organizations, setting up an office or headquarters in Hong Kong? How can we further promote Hong Kong as an international legal hub? Secretary, please. Thank you. I have a good news. The number is no longer accurate. Today, Iran already become signatory states although only 14 have completed the ratification process. If we're talking about international convention, for signatory states and contracting states, I believe that the ratification process for this piece of convention is quick. After signing up, we need to go through a ratification process. But I believe that all signatory states are committed in joining the convention. So what does ratification mean for a convention? Different countries have different rule of law mechanism. After becoming a signatory state, they have to go through internal procedures within their country. And it largely depends on their own arrangement. I believe that the signatory states will keep in close communication with the Secretariat of the Convention, and I believe that all signatory states would want the ratification process to be completed as soon as possible. If Hong Kong is aware of any further explanation or assistance needed by any signatory states, we will try our best to help them. We believe that we'll see more and more signatory states to the convention in the future. Your second question. Let me do some stock taking. HKCH is already here, and Citro already have an office here, which is a project office. UniJoy is already here. So all the three sisters are here. If possible, of course, we want more international organizations here. But if we're talking about renowned organizations, there aren't that many. We do have a close connection with most international organizations. They don't necessarily need to have an office here. Mr. Fan, if you have any suggestions, please let me know. I'll reach out to them. Next, Dr. Junius Ho. Madam Chair, I, of course, support building Hong Kong into an international dispute and resolution, legal and dispute resolution center. We need the support of many entities and organizations. With the support of our country, the headquarters of IOMED is established in Hong Kong. In December last year, Professor Teresa Chung, SE, said that there's a case involving a state-owned enterprise, which is a maritime dispute that have been resolved in the IOMED. This is a piece of great news, of course. We have the Bar Association, the Law Society here. There are 900 firms under the Bar Association, 1,400 members. All of them are elite. How do we mobilize all these talents? How can we include them? I don't really understand the reasoning. Now we have an UniDroid. I don't really know what that is. How do we factor that into our equation? What is the synergy? I fail to see it. The Secretary is working very hard on improving our legal talent training academy, but it seems that we don't have that many legal professional bodies here. Secretary, we have so many international organizations here, but they don't fall within our purview. What are we trying to achieve? What is the KPI? I'm glad that we have completed our first dispute case in the IOMED. What is the rectification process like? But we need to be goal or and result oriented. I try my best to help. In last March, I went to Foshan. The University of Law published a book on how to resolve dispute. They have a new idea, that is mediation first, arbitration later, arbitration next, and litigation later. Arbitration and litigation should be mutually exclusive. Under what circumstances should we mediate first, arbitrate next, and litigation later? How do we resolve disputes? If we don't process all the cases, there will be problem. We want to restore order by all that we do. What I'm trying to say is that we all can help. You can assign work to us. The Law Society just purchased an office worth billions of dollars. I think that we need to utilize our talents. Mr. Roden Tong, the president of the Law Society, is talented. What is our KPI? Can we not work all together towards a goal? Thank you.
All right, your questions are already very clear. First, you want to know more about the nature of UniDroid, how people could clearly understand its role, and the implications of the establishment of UniDroid in Hong Kong, and what are the KPIs, right? Well, let me put it this way. We often look forward or welcome collaborations with the legal professionals. We're working in partnership. We really welcome partnerships with like members of the Bar Association and Law Society of Hong Kong. Of course, we're open. Well, it's not just DOJ working in silo. Of course, we welcome collaboration with you all, and we rely on your assistance and support. We're talking about IOMAT. They just announced that they have resolved the first case. It's a maritime case, and they actually have employed a local lawyer in carrying out this mediation work. I think this morning he received interview from the media. This is a very good example, but then it's just the starting point. On the list of mediators, as I mentioned just now, the country can put forward 30 names, and among them there are 10 from Hong Kong. So it shows that the country has accorded great importance to the mediators of Hong Kong. So with more and more rectified mediators, more and more rectified signatory states, when people get to know us more, I believe that we could have more collaboration opportunities or opportunities to participate in their work of other signatory states. As for UniDroid, different countries are handling different cases. They might have different legal system. And very often, this kind of disparity or differences would hinder the handling of international cases. There might be some soft law or model law or instruments that could be used as guidance so as to reduce the friction between the different legal systems of different countries and states. So in promoting international order and fostering closer international collaboration, UniDroid will be playing a very important role. Well, for Hong Kong, we will play a very important role in capacity building. For instance, in fostering a fair environment for international exchange, we will be promoting the importance or the soft power of Hong Kong. There are, of course, a lot of new concepts coming up, but then it has to be built under the framework of one country, two systems. We have to make use of our strengths and then to make our services more user-friendly. We welcome your views, and I really like to thank members for giving us your valuable views. We will not assign, of course, we are not in a position to assign work to you, but then we are open. If you have any suggestions and recommendations, please let us know so that all stakeholders will have the fair chance to participate in the work. Okay, next is my time for putting questions. Of course, I am in full support of the DOJ, and we're glad to see that the country is according great importance to Hong Kong, and we're glad to see that the IOMAT can be established in Hong Kong, and also the liaison office of Unidroid will be set up in Hong Kong and start operation in Q4 of this year. So this year is really an exciting year. We see a lot of great developments in Hong Kong. And in the paper regarding IOMAT, I think we could promote it a little bit more internationally. Some people might think that the signatory states, IOMAT is only handling dispute resolution between signatory states. But then it's not the case. I'm glad to see that in paragraph 15, it states that the government is encouraging enterprises to submit their disputes to the IOMAT. I'm glad to see that the government is promoting mediation, not just on the civil level, but also encouraging enterprises to consider IOMAT for handling commercial disputes. Could you tell us a bit more about the work in this direction? That's my first point. And second, I'm glad to see that the Bar Association of Hong Kong mentioned that they have been having exchanges and collaboration with Unidroid in the past years. And on the paper, I could see that with the opening of the liaison office in Hong Kong, we can rest assured that there will be more such exchanges in the coming years, well, including the representatives of the signatory states of Unidroid could come to Hong Kong and carry out exchange with our legal professionals. I'd like to know about the resources of DOJ. I hope that you would have ample resources and also have further contact with the two legal professions so as to give their members more chance to participate in the work of Unidroid. Yes, we are very glad to see that the central government is very supportive of Hong Kong in building up ourselves as a legal hub in the region. And of course, the government has to play model role. First of all, Hong Kong as our government will often enter into agreement with other judiciaries or signed international treaties and conventions, for instance, protection of commercial interest treaty, and also double taxation agreement and so forth. Well, there often will have a dispute resolution clause on these documents. So in the future, when we're talking or discussing about the signing of this convention, we will try to suggest to the opposite party that they should include one such clause in their convention. That is to resolve disputes in the liaison office of Unidroid in Hong Kong. And also in signing commercial or civil treaties, we would also encourage the signing parties to consider using Hong Kong as a place for disputes resolution. In government contracts, we would also do that. On that basis, Well, in the future, whenever appropriate, for government contracts, especially those with commercial elements, we would persuade the signing parties to add a clause stating that they would use Hong Kong as mediation dispute resolution center, or they would adopt a mediation first, arbitration next approach to dispute resolution. And next, about the exchange of talents, we have secondment programs. We also have private practitioners who had the chance to go to work in Rome for a short period of time. Well, of course, in Hong Kong, they have their own work to do, but then for the liaison office, they are recruiting a liaison officer and also office manager. But in doing the work, they would need more people to help them out. So I believe that the Hong Kong young legal practitioners would have the chance to participate in the work of the liaison office of Unidroit in Hong Kong. It could be on a regular basis or on a need basis. We will keep in close contact with the liaison office, and whenever possible, we would open up these opportunities to local legal professionals. But of course, we are open and we are inclusive. These positions will not be restricted to Hong Kong professionals. We also welcome people from the Asia Pacific region. But of course, we would try to take care of our local talents and give them these learning opportunities. Yes, thank you. And I think the financial support will also be important. I think we could provide the support to the signatory states. Well, of course, I hope that would be the case, but then this is very challenging. We have to think very carefully. So talking about resources or money, I hope that the LegCo members could help us out too. All right, I'm sure that members have heard that. We would extend the meeting for 15 minutes. The scheduled end time is 6:30. Now we have Professor Priscilla Leung lining up to put questions. 10 minutes, please. Thank you, Chair. Of course, we do look forward to have more resources to the legal profession, to the judiciary, in order to carry out these very important work. And our country has put in great hope to us, but I also understand that resources would be essential. I think we have to achieve 3 goals. First is to establish our brand. We already have very good reputation, but I really hope that we could become the top-notch legal institution in the world. And second, we need to have commercial or income sources. That's important too. And third, about the talents, nurturing of talents. In the recent years, I have a lot of chance to play host to overseas visitors. There was one country from the Belt and Road, but then the representative didn't know anything about the IOMAT. Only after coming to Hong Kong, he then learned about the importance of IOMAT, and he said that he would write a report saying that being a signatory state has no harm. It would be very helpful to become a signatory state. And so I think we have to do more promotion, and we should really help out the IOMAT to have a higher presence and to promote its brand internationally. Well, I've been working on the promotion of mediation first, arbitration next. I often go to the Belt and Road countries, and I try to promote international mediation. I think we have to adopt a 3-pronged manner. First, litigation, court litigation, and mediation. I think we should have a very clear division of duties or work. For the courts, of course, we have excellent courts. We have top-notch courts in Hong Kong. They would want to have good cases as well. For arbitration, we are already doing very well. For mediation, we should think of how we could have a mediation clause in our different conventions. We actually have to promote mediation in the commercial chambers, especially those doing international trade. We have to tell them time and again, over and over again, about the importance of mediation first, arbitration next. And third, about nurturing of talents. I hope that the IOMED could get hold of more resources so as to nurture more talents to help out in this work. Well, of course, we need to train local talents. We have to nurture these talents. They should be well versed in international private law and public law. Well, actually, there are not many people who are well versed on this front. Well, in the past, we didn't need to work on these areas, but then nowadays it's different. Well, just like in 1997, we did have a lot of cases, but then we couldn't even imagine that after reunification with China, we had a lot more cases for arbitration or mediation. So we also have to work in line with the development of our country. But then at the same time, overseas talents are also very important. Overseas people or learners are very important if they come to Hong Kong or come to join our courses in Hong Kong. After that, they would go back to their home country and then do promotion for us. So this would also be very important. We should try to attract the legal professions of these countries, especially those along the Belt and Road, to come to Hong Kong to get to know more about our important legal institution. And then after spending time in Hong Kong, they would go back to promote Hong Kong and to let the people know the importance of the IOMAT and also the UNIDROIT. Thank you.
The Secretary, I think you've heard her. Professor Lin also thinks that we need resources. Thank you. I do agree that we need resources because we need to launch promotional campaign. We're proud that we are a leading jurisdictions adopting common law. We should not assume that everyone knows that we use common law. We need to stay humble. We need to continue to promote ourselves, especially for places where we are trying to reconnect. For South America, some African countries, they may not fully understand our position. They may not have heard of what one country, two system is. So we think that we need to step up promotion and publicity. We need to tell everyone what we're about, how we can help them. All these are about resources. Second, we need to nurture our own legal talents. We need to make sure that they can keep up with the time. On capacity building, experience sharing, all these are important. We need to make sure that professionals in other countries know what we are and what our system is. If they don't have a full understanding of our system, the room for collaboration may be limited. For talent training, it takes time. Everything is about resources. So lastly, I hope that when we submit funding proposal, I hope that the LegCo members will support us. We've heard you. Now on the list of outstanding items for discussion, we do have an item on the Legal Talent Training Academy and the progress of capacity building. We may discuss it on some other occasions. If there's no further comment, I thank the Secretary and his team for coming. Also thank the Bar Association and Law Society for coming. That's the end of this item. Next item, any other business? Any AOB? If not, meeting adjourned. Thank you.